No problem. Thank you.
You're welcome.
Brother.
Okay, so welcome everybody. So nice to see you here today on this rainy Wednesday. In case you don't know who I am, I'm Wendy Rosenberg, Vice President of South Florida Title Associates, the Sawgrass, now Niscaya Square, Nob Hill branch. I've been in the title business for over 30 years now. I'd like to say I started when I was 12. So if you have any questions about title, please feel free to reach out to me, because if I don't know the answers to your questions, I do know where to find the answers to your questions. I have an amazing team at South Florida Title Associates. We have bilingual processors and closers. We can close anywhere in the state of Florida. We can close refinances, short sales, foreclosures, commercial properties, any real estate that's located in the state of Florida, we can close. Okay, we also work with notary closers, remote closers, RON closers, whatever you need, we can accommodate your closings for properties in the state of Florida. Okay, and I do like you to know that we are doing a really amazing job at South Florida Title Associates. I see a lot of you that have been working with me, and you know what a great job we're doing. I'm getting tons of compliments. Our fees are super reasonable. Our settlement fee is only $5.85 to the buyer and $5.85 to the seller. I know a lot of people hire attorneys for the seller side, but if you don't, our charge for the seller doc prep is $5.85. We don't charge extra for notaries that are in our office. It depends on what kind of remote notary you use, if there is an extra charge incurred or not. Most of the time there's not. Everybody says, what does your title company do for you? So those of you that have been on my Zoom meetings, you know that I put on really great trainings for you, and that's my give back to you, that I offer you great training classes that you don't necessarily get everywhere else. I really try very hard to find great, interesting topics and interesting speakers for you, ones that you don't necessarily hear everywhere else. And it takes a lot of work for me to put all these classes together, coordinate it, and send you copies of the recording, copies of the slides when I can. And in return, I hope that you are going to think of me when you have a closing and you need a title company. And I always say, listen, I don't need all your business. I know a lot of you have your in-house title companies, your favorite attorneys. But if you just think of me on your next deal or the one after, I'd be super thankful. And I'd really appreciate it. And I know that we do an awesome job. And you guys, when you work with me, I try to do all my closings that I can personally, so that I get to meet you all in person if we haven't met, and I meet your clients and we establish a relationship. And you have my cell phone number, and anytime you need anything, you can call me. I know a lot of you call me when you have questions about title, even if it's not my deal. I'm happy to help you. I'm always here for you. So I'm always here for you, and I really hope that you're going to try to be here for me. I have a great presentation today with Alexander Johnson. He's going to talk about landlord tenants. I've had him on before, and he's super, super knowledgeable, and I really love the information he has. He does ask that you put your questions in the chat, and when he's finished his presentation, we'll go over all the questions. And I will send you a copy of the recording, so don't worry, sit back, relax, enjoy the presentation, and you can feel free to share it. You know, if you have anybody that would be interested in the presentation that missed the class, feel free to share it. And there's also a link in the bottom of my emails to pass on to anybody that might want to sign up to be part of my email list. So I'm here, and take it away, Alexander.
All right, thank you, Wendy. So my name is Alexander Johnson. I'm a attorney. I've been practicing for 33 years in Fort Lauderdale, Florida, and I do real estate law and landlord tenant. And the presentation I'm about to give you is actually a Florida Bar approved CLE course. So we will go through that, and if you keep the recording, I think you'll find it a good reference to landlord tenant. I do realize that frequently realtors are put in the spot of having to handle your client's tenants on their behalf. And the landlord tenant law is very rule driven. In fact, it is completely governed by statute, Florida statute, chapter 83. So it's not common law. I'll often hear somebody that doesn't know what they're doing talk about quiet enjoyment. That's a common law concept, but in Florida, everything with landlord tenant has a rule. And where there's a rule, there's a form you have to use. So it's all very specific. And Wendy, I'm going to share my screen and we'll start
Sure.
going through the slides.
Got it.
Okay, are you seeing my screen?
Yes.
Excellent. So welcome to the course. I'll start off with my website is browardlandlord.com. And on the site are all the forms that you would need to use as a landlord, even a lease that you can use. Because as you know, preparing a lease is the practice of law. So as a realtor, you're normally constrained with having to use the FAR lease. But you could also use my lease, which is for free for you to use, which is more pro landlord. So also as a preface, as I said, that Florida residential landlord law is governed by chapter 83. When you use that FAR lease, that is the same as the statute. So everything in that lease, which is a pretty long lease, is also required by law, even if you don't have a lease. So that's how many rules there are. So whether you have a lease or not, those are the terms. You are not allowed to vary those terms. Okay, so I'll start off with tenant screening. So the first part in a landlord-tenant relationship is you're taking the applications. And if you're doing your job correctly, you should be screening your tenants. So it's not just a credit report, although that's part of it, but also you're screening your tenants for criminal infractions and also to make sure they're not a sexual predator. So I have a service that does that. It's completely computerized and all the different factors are pre-programmed in. So literally the computer is making the decision of pass, fail, or maybe. And the reason that's important is that HUD, the U.S. Department of Housing and Urban Development, in 2016 put out a ruling that stated that there is a problem with discrimination in housing. And one of the problems with discrimination is that minority groups tend to be arrested disproportionately compared to other groups. Therefore, to treat non-felony convictions as a grounds for denial of housing is going to have a disproportionate effect on minorities. And HUD has said because of that, you are not allowed to turn away an applicant because of anything short of a felony conviction. So in red, I've highlighted the no-nos. So felony convictions over 10 years, not to be considered. If you think about it, you commit a felony, and these days, a lot of even minor things that rise to the level of a felony. So just imagine that you did something and you were not able to rent an apartment for more than 10 years. So the felony convictions time out after 10 years. The landlord is supposed to do an individualized assessment of the applicant, taking into account the nature and severity of the offense, the age of the applicant, their rental background, and evidence that they have rehabilitated themselves. Misdemeanors are no longer grounds for turning down a tenant. Possession of drugs and drug paraphernalia is also not grounds for declining a tenant. Also, arrests or anything that results in other than a finding of guilty is not to be considered. So your safest thing is to have a screening process that screens all that stuff out. So on my reports, if you have something that you're not allowed to consider, it's not even going to be on the report. Because if you're not allowed to see it, you really shouldn't be seeing it. This is a big problem with condo associations that do their own screening of tenants. And I do get a lot of complaints that it's not the landlord that's turning the applicant down, it's the condo. And for an impermissible reason, like an arrest or a misdemeanor or something more than 10 years old. So that is all something that can result in you being found guilty of housing discrimination. So as licensed professionals, that's not what you want to have happen. Something new that happened for the first time in Florida history is last year, counties started passing their own landlord tenant laws. So up until last year, this was something exclusively regulated by the state of Florida. But because of the rental crunch, starting at the end of the pandemic, where rates went up so much and housing was so scarce, Dade, Broward, Palm Beach, and Hillsborough counties passed their own set of laws. So since we're in Broward, I'll concentrate on the Broward law. So they passed a tenant bill of rights, which you see a copy of here. And essentially it has two components. One is that you are required to give a copy of this tenant bill of rights to all applicants and all existing tenants. You have to have a signed receipt that it was given, and you have to maintain the records for 1 year after the end of the tenancy. Secondly, that if you're, as a landlord, imposing a late fee, you have to give a notice of the late fee and state the amount of the late fee, the basis for it, and proof that you've delivered the notice of the late fee. So that is it for the tenant bill of rights in Broward. Dade has a tenant bill of rights that's much stronger, but this is all that Broward was willing to do. The other thing that's interesting is that it has a little bit of menacing language that code enforcement has jurisdiction to enforce it, but it also states it doesn't create a cause of action. So that leads me to think that it doesn't matter if you obey the tenant bill of rights or not. And as we go through this, you'll see that there's some rules that don't have penalties, so you don't really have to worry about them. But on its face, you're supposed to give this notice to all applicants and get the signed receipt. All right, then after you've accepted your applicant, you then have the issue of the lease. So the lease can be in writing or it can be no written lease at all, which is called an oral tenancy. So let's start with the oral tenancy. So that's where you rent to somebody and there's nothing in writing. And there's nothing wrong with that. It doesn't need to be in writing because you literally have all of the rules imposed on you by law. So it's just the same as if you signed that FAR lease. But the way it works with an unwritten lease is the length of the lease is determined by the amount of rent that is paid. So if the tenant pays a week of rent, then that's a week-to-week lease. If they pay a month of rent, that's a month-to-month lease. And if they pay a whole year upfront, which does happen, then you have a year-to-year lease. So just handing over a check creates a lease, and the amount of the rent is what the check was for, and the duration of the lease is how much they paid for. So even though there's nothing in writing, you have to obey all the rules in Chapter 83. So how long does that month-to-month lease last? The answer is forever. So that lease renews by itself forever until either the landlord or the tenant puts an end to it by issuing a notice of non-renewal. So if the tenancy is weekly, the notice has to be given 7 days in advance. If it's monthly, under state law, you have to give the non-renewal 15 days before the end of the month. But Broward, Dade, Palm Beach, and Hillsborough changed that rule last year. And now to stop a month-to-month tenancy, you have to give the notice 60 days before the end of the month. So on the assumption that the tenancy is a calendar month, that the rent is due on the 1st, and So that means the length of the tenancy is from the first to the last of each month. When you end the tenancy, it's not really terminating the tenancy as much as it is not renewing it. So since you're not renewing it, the end date is always the last day of the month. So even though it's 60 days, if I gave you a notice today, April 12th, it wouldn't ripen on June 12th, it would ripen June 30th. So it's 60 days before the end of the month, but the termination date is always the last day of the rental period. Of course, the rental period doesn't have to be a full calendar month. Sometimes it's the 15th to the 15th. But the rule is the same. It can't end on any other day than the rollover date. And the notice has to be 60 days before that. So yes, if I issued a notice today, the 12th, it wouldn't take effect till June 30th. So that's a lot more than 60 days, but I don't have 60 days before May 31st. So now I jump to the next month, June. All right, now let's talk about written leases. So I see a lot of people shoot themselves in the foot with a written lease because they just grab something off the internet from, just like anything else from the internet. You've got to watch out where you're getting it from, because a lot of times you're getting some garbage. So if you're not exactly sure where that lease came from, like a FAR lease, you probably are better off not using a lease at all, because you could cause yourself harm. And as a landlord tenant attorney, I've seen landlords come up with a lease that causes the landlord a lot of trouble. So either use a FAR lease or get the lease off my website, or when in doubt, don't have a lease. But if you're going to have a lease, what has to be in it? So to be a valid lease, it has to have the names of the people. So the name of the landlord, the name of the tenant, the property address, the amount of the rent, the length of the lease. So if it's in writing, it could still be week to week or month to month, but usually a written lease is for a year. And then the granting clause, which is landlord grants to tenant possession of the property, possession meaning the right to inhabit it. And something to bear in mind is that once you've granted the right of possession to a tenant, that right is the tenant. So if you sold the property, you would sell it subject to the tenant's right of possession. Selling the property doesn't cancel the lease, because you have given that right of possession away with your lease. So you don't have that anymore. So all sales are subject to the tenancy. And now that in Broward, terminating month to month being 60 days, that's something to bear in mind if you're thinking of selling your house, that it's going to take a minimum of 2 months to end a month to month tenancy if you're hoping to sell your house empty. So what can you put in the lease that the law doesn't provide? The landlord tenant statute doesn't say anything about late fees, so you can put whatever late fee you want. It could be $50 or it could be $50 a day. There's no legal restriction on the amount of late fees. Security deposit. Security deposit can be anything. Traditionally, it's a month's rent, but it can be whatever you want. Repair obligations. By the statute, if the property is 2 units or more, the landlord is required to keep the property up to code. But if it's a single unit or a duplex, you can eliminate that obligation and say the landlord's not fixing anything, and that's legal. Also, early termination. So if you have a 1-year lease, you have a choice about what happens if the tenant leaves early. The default position is that the tenant did sign a 1-year lease, so they are liable for the rent, but only as it accrues. So if they leave early, as each month comes up, they will owe you that rent until you get a replacement tenant. But if you don't, they'll owe you their rent. But you have the option of changing that, and instead of owing the rent as it comes due, you can have what's called liquidated damages. And the law says it can be 2 months' rent. So if you had a 1-year lease ending December 31 and the tenant leaves April 12th, you could ask for the rent as it comes due, or you could say, well, I have a 2-month penalty. So tenant, you owe me 2 extra months. So I want May and June's rent paid up front as your penalty, but then after you've paid that, you don't owe anything else. The other thing you don't want to have to do in an eviction is a jury trial. So you want a jury waiver in your lease. And lastly, abandoned property. You're allowed to put this in your lease, but if you don't, and there's property left behind, the law says you're supposed to have a public auction. So that's ridiculous. You don't want to have a public auction of the tenant's property, so make sure you put an abandoned property agreement in your lease saying anything that's left behind, the landlord can dispose of it as they see fit. So what is not allowed in a lease? You're not allowed to contradict anything in the statute. You're not allowed to put in a liability waiver saying if the tenant gets injured, then the landlord's not responsible. And for some reason, you're not allowed to prohibit waterbeds. So the waterbed lobby must have a good lawyer. Okay. You'll run across the situation where the landlord wants to remove somebody, but the cause of action for removing someone depends on their legal status. So Chapter 83 is the Landlord Tenant Act, which applies to tenants. So not everybody is a tenant. It could be a guest, or it could be a patient in a hospital, or somebody in a rehab clinic, or an inmate in a jail, or it could be a boyfriend or a girlfriend or a relative. So first off, you have to say, is this person a tenant? And a tenant means it's somebody in a residence that's paying money. So as long as it's residential and as long as they're paying money, whether the agreement is written or oral, that makes them a tenant. So the statute defines a few things that are not tenants, which is if you're staying in a place like a hospital or a college dorm, or if you're a monk in a monastery, you're not a tenant. If you're a buyer, so sometimes you'll have a deal where there's a pre-closing occupancy and the buyer moves in before the tenant, the closing. So if the buyer is there with a purchase contract and they've either paid a year's worth of rent or 1 month of rent and 5% of the purchase price, then they're going to be treated more like an owner than a tenant. So legally, once the purchase and sale agreement is signed, the buyer is the constructive owner of the property. And that means you can't evict them. You're going to have to do something called an ejectment. And we'll get to that later. Also, what's not a tenancy is transient occupancy. So if you stay in a hotel, you're not a tenant. The hotel doesn't have to evict you. You're a guest. And if you don't pay your hotel bill, they can throw you out on the spot. They don't have to file a lawsuit. The same goes with Airbnb. Although what comes up with Airbnb is a lot of times people will stay more than a month. And guess what? At that point, they turn into a tenant, not a hotel guest. So now you will have to follow the eviction procedure. So keep that in mind with the Airbnbs. Once they hit 30 days, they turn into a tenant. Also, if you've ever done a closing with a co-op, when you get title to a co-op, they don't give you a deed, they give you a lease. So even though it says lease on it, you're an owner, not a tenant. So the cause of action. So depending on whether the person is a tenant or a guest or an owner, it's a different lawsuit. And a lot of people confuse the terms and use them interchangeable. And the party that's most guilty of getting these confused is the police. So it's important that you know the difference because the police do not. So if it's a tenant, meaning they're paying rent, then you have to evict them. You cannot remove a human being from a residential property in Florida without filing an eviction lawsuit, getting a judgment from the judge, and that judgment is carried out by the sheriff. So nobody is ever removed from a residence without filing an eviction, winning the eviction, and the sheriff carrying out the eviction. If the person is a guest, so somebody that's not paying rent and they're just staying with you, what'll happen is when this guest is supposed to leave and they don't, then if you're unlucky, that guest will call the police on you, and the police will say, you can't throw anyone out, you have to evict them. So that's wrong, you don't have to evict them, you're not supposed to evict them, but you do have to file a case called an unlawful detainer. So unlawful detainer is to remove guests. So that's anyone that's not paying rent. The difference is that the unlawful detainer doesn't provide for attorney's fees, so that's going to be on you. Claim of ownership. So if the person in the property has a tolerable claim that they have an ownership interest, then you can't evict them, and it's not an unlawful detainer either. It's a ejectment. And in an ejectment, unlike evictions and unlawful detainers, which are cases for possession only, an ejectment is also asking the judge to make a ruling who is the owner of the property and who's entitled to live there. So in my experience, this comes up a lot when somebody's parents owned the property and then they died. So now you've got the different kids and the will. And so the kids are fighting with each other who's entitled to the property. And probably the most annoying of the kids is the one living there. And he's not letting the other brothers and sisters in. So now you want to not only have the judge declare that you're the owner, but to kick your bratty sister out of that property. So something else that comes up with a death in the family is a lot of times the parents will go ahead and deed the property to their favorite child before they die to make sure that there's no fighting. But that other kid, the black sheep of the family, is still going to contest it and say, hey, I was in the will, so how come my sister is saying she's the owner? Well, she's the owner because they deeded it to her. So once it was deeded to one of the kids, it's not part of their estate. So it doesn't matter what the will says, because once you've deeded the property to someone else, it's not in your estate. But you'll still have the person that got left out contesting it. So that's an ejectment, and that is a circuit court case like a mortgage foreclosure. There we go. So next you have to decide which court do I file the case in. And the boundary line is county court is anything up to 30,000 and circuit is anything more than 30,000. So if you have a rent delinquency of more than 30,000, you're not managing your property very well. But so mostly it's county court. The other thing is that county court doesn't have jurisdiction to decide ownership, only possession, meaning who gets to live there. If the tenant's not paying the rent, then you're saying, judge, get these people out of my property, they're not paying the rent. I want possession back. But if there's an issue that the person in the property owns it, then you need to be in circuit court to have the judge say, well, I'm going to decide who gets to live there and who owns it. Next is who can file the case. So as realtors, you may have a snowbird client that wants you to file the case for them. So yes, it is possible for a third party to file the case, but it's very restricted. So if you're a property manager, you need written authority from the landlord that you can file the case for them. You're not going to be the plaintiff. The landlord is the plaintiff, but you're the one filling out the paperwork and filing it. So it's not going to be in your name. You are not allowed to ask for any money judgments. So the case is possession only. You're not asking for back rent or court costs. You also are required to use the Florida Bar forms. You can't make up forms on your own. And lastly, you cannot prosecute a contested case. So if the tenant is fighting the case, you're going to have to go get a lawyer. Now, the landlord can also file the case on their own. They don't have to necessarily use an attorney, with the exception that if the landlord is a corporation or an LLC, they're not a physical being, therefore they must have an attorney. So anything in a business name, an attorney is mandatory. Okay. So grounds for an eviction. the first step of the eviction process is that the tenancy must be terminated. So you probably are thinking that you file the eviction to have the judge terminate the tenancy, but that's not true. You're filing the eviction because the tenancy is already terminated and you're asking the judge to remove the occupant because the lease is over with. So how do you, what's the grounds for terminating the tenancy? Three basic ones. One, they didn't pay the rent. And the law says you have to give them a 3-day notice. And the 3-day notice says pay the rent in 3 days or the tenancy is terminated. So literally at midnight on the 3rd day, the tenancy is terminated. Then if the grounds for the eviction is breaking the rules, then you give the tenant a 7-day notice to cure the violation. And then if it's month to month or week to week, you can end the tenancy by giving a notice of non-renewal, which in Broward, Palm Beach State and Hillsborough is 60 days, and the rest of Florida is 15 days. So first you terminate the tenancy. When it's terminated, then you file the case. All right, so let's talk a little about filling out the 3-day because the landlord may ask you to do this for them. So here's the 3-day notice. You must use this form. Like I was saying, landlord tenant is form driven and they're very strict about the forms. The forms have to be just right or you will lose the case. So what has to be on a 3-day notice? The name of the tenant, and that means the tenants that are on the lease, or if there's no lease, the name of every adult that you expect to be paying rent to you. You don't name the children, and sometimes there may be people that are living there that you don't even know who they are. But you should know at least the people that you expect to be paying rent to. So you name them on the 3-day notice. Then you put the address of the property. So that sounds simple, but let's say that you're renting a 1-bedroom out of your house. So it's like second door on the left. Well, that's not going to cut it for the sheriff's department. They need to know exactly which unit it is that they're kicking people out of. So make sure that your unit is marked. So it has to have a unit number on the door. If it's a room in your house, put a unit number on it. Because I'm not kidding, if the sheriff has the slightest doubt, they're going to throw your writ in the garbage and make you start the whole lawsuit over at the beginning. That is really annoying, especially when you're fighting with someone that's living in the same house as you. So the rent that's due. When they say rent, they mean rent, i.e., don't put any late fees, don't put utility bills, don't put any other charges. You can only ask for rent on a 3-day notice. Anything else is a mistake. Rent only. Now, the date of delivery. So you're going to put, sorry about that. So you're going to put the date of delivery and then the due date. The due date is 3 days the court is in session after the date you delivered it. So if you delivered a 3-day notice today, Wednesday, your 3 days are going to be Thursday, Friday, and Monday. Weekends don't count. Court holidays don't count. Also, here's another caveat that affects us in Florida. Days that the court is closed don't count, meaning hurricanes. So when it's season, sometimes the courts are closed for hurricanes. So if you have a 3-day notice out and there's a hurricane closure, you're going to have to redo your 3-day notice because now there's a closure that you didn't anticipate. The other thing I have to warn you about is that every county in Florida celebrates a different set of holidays. And every year, every county celebrates different holidays than the year before. So on my notices that I have on my site for Broward, Palm Beach, and Dade, I've listed the holidays. And again, there's no figuring it out because they switch holidays from year to year, depending on whether they want 3- and 4-day weekends. So that is an easy place to get yourself in trouble because who knows what holidays they're going to take. It literally changes every year. So pay attention to that. And again, A holiday date may not be a holiday in Broward, so it's not consistent. All right, lastly, the landlord name, address, and phone. So here's something to be aware of, that these notices contemplate the tenant getting in their car and driving to the landlord's address and handing the rent in person. Of course, now we have Zelle and Venmo and direct deposit and ACH, but this statute was written in the 60s. So back then you just had hand delivery. So that's what you have to do. So if you put a PO box for the landlord, you can't do hand delivery. So there's a rule of civil procedure that says in a litigation situation, anything you have to do by mailing it to somebody, the period of mailing is 5 days. So if you give an address that has to be mailed to, you have to add 5 days to the due date on this notice. So now you have 3 days that court is in session, plus 5 calendar days. But if the 5 calendar days ends on a weekend or a holiday, then you default to the next court day. So that gets a little confusing. So I would suggest you just make arrangements to hand deliver the 3-day notice and have a real address on it. And if you don't want to give the address to the tenant, then do care of somebody else to give them a street address. Alrighty, the next notice is the 7-day notice. So this says notice to cure lease violation. This is anything that the tenant's doing that you think is a breach of the lease. So that could be unauthorized people living in the unit, it could be pets, it could be loud parties, parking on the grass. Whatever it is, you list all of your grievances here that you think is a lease violation. And again, you have to use the form. Everything is a special form. And this form says if you don't stop doing it in 7 days, then you have breached the lease. The second part to that is that if the violation is repeated after 7 days, but less than a year, that second offense is the fatal violation and it's grounds for the eviction. So either something that's continuous isn't cured in 7 days or it reoccurs, then that's grounds for the eviction. The other thing about the 7-day notice is that if it's a constant violation, like unauthorized occupant, you cannot accept rental payments while you're accusing the tenant of being in breach. So sometimes it's critical your timing. So if you've got a rent payment date coming up, you might want to make sure you collect that month's rent and then issue the 7-day notice, so you don't have to turn the money away. Now, there's another 7-day notice for incurable violations. And I recommend that you not use this unless the situation is outrageous. And by outrageous, I mean violence or property destruction. So if someone pulled a gun, if the tenant pulled a gun on you or lit the house on fire, sure, it's incurable. But if it's short of that, do the curable. Ironically, even with the guns and the arson, you still have to wait the 7 days. So you really are not solving anything by using this form. But I see a lot of landlords use the incurable form. And since it's usually the wrong form, that means their eviction is going to be defeated in court. All right, lastly, the way to end a tenancy is with a notice of non-renewal. By state law, for month to month, it's 15 days. And Broward, Dade, Palm Beach, and Hillsborough is 60 days. And again, that's not any 60 days, but 60 days before the rent rolls over. All right, what happens if the tenant is dead? So if the tenant is dead, then you get the property back automatically under the following circumstances: that the rent is delinquent, that you've waited 60 days and you have not received notice of probate. So it's automatically yours. You don't need to file an eviction. But what do you do with the stuff that's left behind? And the answer to that is, it depends on what your lease says. So if you have the abandoned property agreement, you can dump it. But if you don't, you might have to do that auction. The one thing that also is a source of problems for landlords is the tenant is dead and somebody shows up and says they're their brother and they want all their stuff. Well, without a probate, nobody really has legal authority to come and empty out the unit. So you're really better off to wait the 60 days and tell that person it's going to be on the curb in 60 days. And after that, I don't care what happens to it. But I'm not really sure it's a good idea to just let anyone who shows up clean the unit out. All right, military tenants. We don't have a lot of military bases in Broward, but other parts of the state do. So there's two main rules with military tenants. One, you have to approve or deny their application in 7 days. If you don't make a decision, it's deemed accepted. And second, that military tenants can terminate the tenancy with 30 days notice if they either get transferred more than 35 miles away, or they die, or they're discharged from the military. All right, for filing the complaint, if you're filing the complaint, you're going to want to go to the Broward Clerk of Court's website and download the forms package. It's like less than $10. And what has to be in the complaint? Usually you have account for possession and then account for damages. If you're a property manager, you're not allowed to do the damages part. But in the complaint, you at least have to state the name of the landlord. So the landlord is not always the owner. Sometimes the landlord and the owner are different. So either one will do as a plaintiff. Then you have to put the name of the tenants, which are the ones obligated to pay the rent, not the kids. You have to state the address of the premises. You have to file in the same county as the property is located in. So you don't file where the landlord is, you file where the property is. And then you have to, if there's a lease, you have to attach a copy. And then you have to attach the notice that terminated the tenancy. So if the tenancy ended on its own, it's the lease. Otherwise, it's the 3-day notice, the 7-day notice, or the notice of non-renewal. The count for possession is a summary proceeding in the state of Florida under Florida Statute 51011. And what does a summary proceeding mean? It means that the tenant only gets 5 days to respond. So in a normal lawsuit, they have 20 days to respond, but for evictions, only 5 days. So since that's such a short time, that's 5 court days, not 5 calendar days. So weekends and holidays don't count as part of the 5 days. The other thing that's unique to evictions is the service of process. So in a normal lawsuit, the lawsuit doesn't start until you physically put the court papers in the defendant's hands. But in an eviction, you are allowed to post the court papers on the door. So to do that, you have to make at least 2 tries, 12 hours apart, and then also mail a copy to the tenant. So I get a lot of calls from tenants that they were on vacation, but they might be in jail or they might be in the hospital. But the landlord can start the case by posting the papers on the door, and that's good service, and that starts the 5 days running. So it's very possible for a tenant to get evicted and have no idea that a lawsuit's even going on. The second count is for damages. That is not under summary procedure. So that's like a regular lawsuit. For damages, meaning unpaid rent, the tenant has 20 days to answer like a regular suit. Also, the service by posting is not good for the money judgment. So if you want to get a money judgment against the tenant, the posting doesn't count. You're going to have to issue another summons and get them in person, or just give up on it and forget about the damages. But posting doesn't give you the money judgment. Now the claim, now you can claim for whatever you want. Even though the 3-day notice doesn't allow you to put the late fees, in your complaint, you can put your late fees, also unpaid utility bills, attorney's fees, court costs, or any property damage. So it's wide open season on the money damage claim. So the tenant has now been served. They have 5 days to file the answer, 5 days for possession, 20 days with regard to the money judgment. So here's something different about evictions than any other lawsuit, that 5 days is hard and fast. You have to respond and assert all your defenses in 5 days. So in a lot of other lawsuits, is all you do for the 5 days is ask for more time, or you file some sort of a motion. But in evictions, you have to file your answer and put forth all your defenses in the 5 days. You can't say, Judge, I want more than 5 days. The answer is going to be no. 5 days is it. So that is different from evictions from anything else. So if you're being sued for non-payment of rent, what's your defense? Obviously, the first defense is that you did pay the rent. So if you are claiming to have paid the rent, then you have to have proof of that. So you can't just say, I paid the rent. You need some physical evidence of that. The second defense to non-payment is that the amount of rent claimed is wrong. So again, you need to back that up with some proof. And then you're going to have to move as the tenant for a rent determination hearing to say, Judge, they asked for $2,000, but the rent's only $1,000. I don't know where they got the other amount. I want you to have a hearing. And you, Judge, you decide how much I owe. So at that hearing, the judge will decide what's owed, and then you will be ordered to pay that in between 1 and 5 more days. The last defense to non-payment is when the landlord is in violation of the lease. So typically that's where the landlord is supposed to repair something and they didn't. So for that to be a defense by the tenant, they have to do the 7-day notice, the same form as the landlord uses when they say the tenant is doing something wrong. So the tenant gives the landlord the 7-day notice to say, landlord, you're supposed to keep this place up to code. You didn't do that. Therefore, you're the one in breach of the lease. And then you move for rent determination. And now the judge is going to have a hearing and ask 2 things. One is, what, if anything, did the landlord do to fix the problem? And 2, how badly depreciated is the property? So the judge is going to decide the lack of enjoyment from what you paid for if the place was in good shape. So if it's like a 2-bedroom, 2-bath, and one of the bathrooms doesn't work, then what percentage of rent should be removed? Or I had a case where the landlord cut off the cable TV and the judge cut the rent in half because he said, in his opinion, cable TV is the most important thing in a property. So that tenant got 50% rent reduction. So here's the thing with the 7-day notice is obviously 7 days is more than 3 days. So it's a race to the finish line. So the landlord is giving a 3-day notice to pay the rent. The tenant has to beat the landlord to the punch and make sure their 7-day notice ripens before the landlord's 3-day notice. So obviously, if you're the tenant and you got a 3-day notice, you don't have enough time to do the 7 days. So you don't get that defense. But if you've done that previously and your notice is ripe now, then you will have a defense. All right, so another thing unique to evictions is the statutory requirement to pay the money to the court registry. So when you're being evicted for non-payment, if you don't have one of those defenses that you did make the payment or the amount is wrong, then you're required to pay the rent claim to the court in the 5 days, no exceptions. So that has to be paid to the court, and you have to keep paying the court registry as the rent accrues. So let's say that your case starts in April, but it goes to May, and May 1st is a Saturday. Well, now you have to pay the court the rent before May 1st, because there's no grace period once the case has started. So if May 1st is a Saturday and you pay the rent May 3rd, Monday, you're late and now you'll be defaulted. So there is no exceptions to this 5-day payment of the rent. Now, there's a couple of other defenses where you might not have to pay the rent, which is 1, you're not a tenant. So we were discussing that not every human in the world is a tenant. You could have some other relationship other than a tenancy. So if it's not a tenancy, then why would you pay the rent? Because you're not a tenant. The other thing is sometimes the landlord is the wrong person. So that could be a corporation that does in fact not exist, or it could be the wrong person. I had a case where the landlord lived in Atlanta. So her brother filed the eviction for her in Miami, but he filed it in his own name. He had no legal relationship to the property. So obviously that case got dismissed because he was the wrong guy to bring the lawsuit. So you could have the wrong party, or the fact it's not even a landlord-tenant relationship. Now, once the money's in the registry, the landlord can ask for it to be dispersed to them even before the lawsuit is over. And for that, you'd have to allege that you're having a financial hardship. So even though evictions are expedited proceedings, they don't always wrap up in a few weeks. Sometimes they will drag on for a long time. And the landlord will say, hey, I've got to pay my mortgage and my insurance, so I can't go 6 months without any rent payments. I want the money. The second thing is, I've never really seen a case where even if the landlord lost the lawsuit, they didn't get the money in the registry. So you might have lost the lawsuit on a technicality, but you're still entitled to the rent. So usually the money in the registry is going to the landlord, whether they win or lose. So after the 5 days is up, then you have to see what has the tenant done. So number one, they didn't do anything. There's 5 days are up, nothing has been filed with the court. So now you run into this law. It's a federal law to protect soldiers that are fighting in wars abroad. It's called the Soldiers and Sailors Relief Act. And that requires that in any lawsuit where the defendant didn't answer, and you're asking to take away their property, which would be an eviction or a foreclosure, the plaintiff, the landlord, has to prove to the court that the defendant is not active duty military. And there's 3 ways to do that. One, a sworn affidavit from the plaintiff that they're not active duty military. But don't think you can get away with just saying, okay, they're not military. The judge is going to want you to tell you why. So it's not because you don't think so. You have to prove it. And the judges do look at this. I've had the judge bring the landlord in and question them under oath. Why are they not military? You better have a good answer. Second, a written admission from the tenant. So on that score, I recommend that when you write up your lease, at the end of the lease, right above the signatures, you put a little statement, I am or I am not active duty military. So they check off I am not, boom, you've got your admission and it's no longer an issue. And then lastly, you get a certificate from the Department of Defense. It sounds complicated, it's not, because they have a website that'll give you a certificate on demand as a PDF file, but to get it, you need the tenant's date of birth or social. So if you've done your screenings, you should have that, but sometimes people will buy a property with a tenant in place, and for some reason, the parties messed up and they didn't get a tenant estoppel letter, which someone like Wendy would make sure you had. But if you don't know anything about these people, then you're not gonna be able to get the certificate. In that case, you might have to hire a skip tracer and investigate their identity. It's not that expensive, but you can't proceed to a default without that non-military affidavit. So now instead the tenant does file an answer, but they didn't pay the rent. So they file an answer and they say, oh, judge, this place is in rotten shape. The landlord doesn't repair anything, but they don't have the 7-day notice that had ripened before the 3-day. So it doesn't matter about their complaints. They were required to do that 7-day notice. And if they didn't, it doesn't matter about the repairs. So the judge is not going to listen to any defenses you have if you didn't pay the money to the registry. So in that case, the landlord files a motion to strike and the eviction is granted. So scenario 3, the tenant does answer and pays the rent to the registry. So now you're going to get a hearing. So right or wrong, if you paid the money to the registry, the judge at the minimum is going to schedule the mediation. So if that happens, there's going to be a hearing, maybe a trial. Right? Sometimes the case will settle. So the parties have the ability to reach a settlement at any point until the tenant's actually been kicked out by the sheriff. So what you don't want to do is just say, okay, tenant, I'll collect your rent money and I'll dismiss the case. That's not the good way of settling. That just means you wasted all your money on the lawsuit and didn't get anything out of it. So what you want to do is to sign a settlement agreement. And that agreement is going to have the following components. One, a payment schedule where the tenant is going to catch up on the rent, plus to pay you your court cost and attorney's fees, and that may happen in installments. Second, you're going to state that if the tenant violates the settlement, that is all you have to do is file an affidavit of noncompliance, and the court will grant the eviction with no hearing. And also, you may decide in a settlement that you don't want the tenant out immediately, but you also don't want them to wait to live out the rest of the lease. So it might have an early termination date. So whatever is in the settlement, once that's filed, the judge is going to stamp it, turning your settlement into a court order. Meaning if the tenant doesn't do what the order says, then the judge will enforce that order by granting the eviction on request. So no hearings, no new lawsuits, no additional notices, they're out. You get the writ of possession immediately. So with that in mind, you want your settlement to last until the end of the lease. So you don't want a settlement that ends before the lease does, because effectively you're putting the tenant on probation and maintaining the ability to reinstate the same lawsuit without starting over at any point. All right, if you lose the case and you feel that you were done wrongly, you can appeal. So you have 30 days to appeal the judgment. And if you're in county court, the appellate court is the circuit court. So that's the next highest court. If you're a tenant and you felt you lost wrongly, you may have to post a bond. And also just filing an appeal does not stay the writ of possession. So obviously, if you're the tenant and you lost, then the eviction was granted and the writ has issued and the sheriff is on his way over to kick you out. So you have to file separately to stay that writ, or you may have a live appeal, but you'll be out of the unit. Security deposits, a source of a lot of problems and something that landlords need to be really careful about. So number one, this is an area where there's rules but no penalties. So 8349 is the part of the statute that deals with deposits, and it says that security has to be held in a Florida bank and not commingled with operating funds. So I get a lot of calls from tenants saying, and by the way, the tenant didn't put my security in escrow. What's the penalty for that? And the answer is, there is no penalty for that. So if you're the realtor or the landlord, don't worry about it. There's no penalty for not escrowing the money. Notice requirements, you're supposed to give the tenant a notice of where you're holding the deposit. And if you move it where it got moved to, same thing, you're supposed to do it, but if you don't, there's no penalty. Bailment, this is something to think about as a realtor or a manager, which is legally the security deposit is the tenant's property. And bailment is the legal term for when you're holding someone else's property. So as the custodian of another person's property, you're liable for it. So people like me and Wendy that are escrow agents know that if you let money out of escrow wrongfully, it's your butt. So the same with the security, it's the tenant's property. And if it goes missing, you are liable for it. So that may happen that the realtor collected the deposit and put it in their own escrow account. So that makes them liable for it. Or it could be the manager, it could be the landlord, but whoever took that money is responsible for its disposition. So bear that in mind. As an agent or a landlord, you don't want to be sitting on that security deposit because that makes you liable for it. All right, it is the tenant's money. So for you to claim on it, even though it's in your bank, you have to follow these rules, which is if you're going to give it all back, you're supposed to give it back in 15 days. But if you're not going to give it all back, you have to send a certified letter to the tenant in 30 days. So that means the postmark on the letter is within 30 days of when the tenant moved out. No other method of delivery, including hand delivery, is acceptable. It must be a certified letter. So the tenant could be standing right in front of you and you hand them the notice. No good. Certified only. So scenario 2, the tenant takes off, doesn't give you a forwarding address. You still have to send the certified letter. If you don't have a forwarding address, send it to the vacant unit. If that's the best address you've got, then that's where you send it. You're not required to hire a private eye to figure out where the tenant is. But if you know where they are, you cannot deliberately send the letter to the wrong address because they didn't officially tell you. So if you know where they are, even though they don't have proof of giving you a new address, send it to the best address you've got. You don't want, so if you don't do the claim properly, no matter what kind of damage the tenant did, you have to give the whole deposit back. So they could have damaged everything, but without the proper claim, you have to give the whole deposit back. Now, that doesn't mean you can't sue the tenant for money damages. So I've had plenty of cases where the landlord didn't do the certified letter, so we're going to get our deposit back. But then the landlord files a counterclaim for damage. So you may have crossing judgments where I get a judgment for the deposit back and the landlord gets a judgment for damages. So how is that a win? It's a win because the landlord is going to write me a check and the tenant is not going to write the landlord a check. Why not? Because there's nothing the landlord can do about it. The landlord has real estate. When I get a judgment on the landlord, that judgment is a lien on his real estate. But the tenant doesn't own real estate. He's renting. So you got a lien on nothing. So I will even settle a case where the tenant agrees to pay all kinds of damages. They can agree to pay it because they're not going to. But the landlord is going to pay the deposit back. All right, so you're making the claim. What can you claim and what can you not claim? We'll start with not claimable. The standard for claims is that the tenant is entitled to ordinary wear and tear in light of the duration of the tenancy. So if they are there for a year, that's a moderate amount of wear and tear. If they've been a tenant for 20 years, then they get a lot of wear and tear. So bear that in mind. How long have they been there? In general, the place is not required to be room swept. It's not required to be move-in. They're only liable for damage more than ordinary. So in general, that means you can't charge for cleaning. So typically landlords charge for cleaning the kitchen or bathroom. That's generally a no-no. Routine painting, unless the tenant like punched holes in the walls or sprayed graffiti on the wall, routine painting is not chargeable. Remodeling, I've seen landlords that say, okay, now that the place is vacant, let's do some improvements. Let's put in a nice granite countertop. And then they keep the tenant's deposit thinking, boy, that granite countertop was expensive. I could use some money for help me out with that. You can't bill the tenant because you wanted to upgrade. So don't do that. What you can claim, unpaid bills, so you get stuck with an unpaid water bill. Water bills are from the government, so they're generally a lien on the property. Theft, meaning they didn't return the keys or fobs, or they stole things like they stole the window blinds, or maybe they even stole the appliances. So anything that was stolen, you can charge for. And then lastly, breakage. So anything that was broken, you can charge for. It's best that you have receipts for the things you're charging for. So in general, you're on thin ice if you charge for like a broken dishwasher and then you didn't replace it. The same old dishwasher is there for the next tenant. So you're like, well, why was there a charge then when you did in fact not replace anything? So lastly, with security deposits, here's why it's dangerous for landlords, is that if the tenant recovers any money at all, not the majority of what they asked for, even if they get $1, they're considered the prevailing party, which means they get all their attorney's fees. So if there's attorney's fees and the case has gone all the way to trial, the attorney's fees are going to be more than the deposit. So as a landlord, you're in a predicament because the only way to win the case is that you take it to trial and the tenant is awarded $0. All right, so in that case, you're the winning party and then you get a judgment for your fees, which you're not going to get paid anyway. But if they get even a little bit, then they're the winner and you have to pay their fees, which is more. So mostly it doesn't make sense to fight claims on security. So that's why I say if you're a landlord, Number one, be very cautious about what you claim, and number two, if a lawyer calls up for the tenant, you should think seriously about just paying them what they want. Because unless you win like 10-0, you're gonna pay their attorney's fees and then you'll end up losing. So I did have a case where the parties insisted on taking it to trial. I was representing the tenant. They spent $4,000 in attorney's fees. The deposit was $2,000. So even though they won the case, the tenant didn't pay the judgment and it cost them $4,000 to save $2,000. So I don't see how that was a good financial decision. All right, landlord's duty to maintain the premises. The landlord is supposed to keep the property up to code, which means pest control, locks and keys, maintenance, garbage removal, heat and hot water. Ironically, Florida law requires the provision of heat, but not the provision of air conditioning. So that's a little bit weird. So the landlord should inspect the property before the tenancy to make sure that it's in safe condition. But if there's something broken, the landlord's not responsible until the tenant has told them about the thing that's broken. So what's the concern about that? Not that they're not going to pay the rent, but let's say they get hurt because something was broken. Now they're getting sued for personal injury. And then as a reminder, if it's a single family or a duplex, you can waive your repair responsibilities completely. So here's my strategy is I put in my lease that I'm not doing any repairs as the landlord, but I don't make a big deal about it. And most people don't know what the word abrogate means anyway, so it doesn't come up. But where it does come up is that something is broken and the tenant says, hey, landlord, there was a roof leak and my TV is busted. I want a new one from you. And then that's when you pull out the lease and say, let's see, who's responsible for repairs? Oh, you are, Mr. Tenant. So go replace your own TV because it's not my fault, because I'm not responsible for repairs. So that will be a lifesaver. I don't let tenants do the repairs. Again, when you have this clause, they ignore it. They're still going to call you when the toilet is clogged, and I go and do with it. I don't want them pouring Drano down the drains and destroying my pipes. So I still do the repairs, but if it looks like someone's about to sue me for personal injuries, then it's going to be very important who's legally responsible for the repairs. So that's also a way around the legal provision that you can't tell the tenant you're not liable for injuries. But if it's injury because of a repair and you're not responsible for the repair, then you're not responsible for the injuries either. So if the landlord has a duty to fix something and they're not doing it, again, the tenant has to do the same 7-day notice as the landlord has to do. So they have to put the landlord name, they have to list everything that's wrong, and then they have to state, and again, it's a form. You have to use the form that's in the statute. So the deal with this is that once the landlord gets this notice, they then have to make a reasonable effort to do the repairs. Now, they don't have to finish the repairs because some things can't be done in 7 days. And in fact, there's some things that can't ever be done. There was some cases with a rat infestation, and try as hard as they could, they just couldn't get rid of all the rats. Or it could be that there's a part you need that's not available and it takes a while to get it. So the landlord's duty is just to make a reasonable effort. If they've done that, then the tenant doesn't have their defense to move out or not pay the rent. But so that's to bear in mind as the landlord. But if you do get one of these notices, then you should talk to a lawyer, because that means the tenant knows what he's doing and he's getting ready to either not pay you anymore or to move out. Right of entry. Another source of fighting is, when does the landlord get to come into the unit? And you've got the 3 categories: with consent, without consent, and the tenant is missing. So the landlord is allowed to go into the dwelling unit whenever they want to on 24 hours written notice to protect or preserve the premises. So that means, let's say that there's a leak. So the landlord can't let that leak go on. They need to get in there right now and stop it, or there's going to be more damage. Also, the tenant can come in without consent, or the landlord can go in without consent when the tenant is unreasonably refusing entry. So let's say you've got your exterminator coming by and they're like, no, that's not a convenient time for me, and not letting them in. And you're like, well, it's my responsibility to exterminate and you're not letting them in. And so if you refuse too many times, I'm just coming in anyway. So again, 24 hours written notice, and the entry can't be before 7:30 in the morning or after 8 o'clock at night, and probably not on Sundays. Also, if the tenant is missing, and there's a reason and you know it, like they're on vacation, and the rent is paid, the landlord does not have carte blanche just to snoop around in the unit. All right, prohibitive practices. This is something that there's a punishment for. This is also called constructive eviction or unlawful eviction. This is where the landlord does one of these things in red. One, cut off the utilities. So if the landlord cuts off the electricity, cuts off the water, and I told you about the case with the cable, they cut off the cable, that's considered an unlawful eviction, and the punishment is 3 months rent, attorney's fees and costs. So to simplify it, I say that if you remove any lease amenity that existed when the lease started, you've committed an unlawful eviction and you're looking at 3 months rent. So here's the rub, because I'm defending one of these right now. The landlord cut off the water, spitefully probably, but the tenant has a very aggressive attorney and he's litigating the hell out of this case. And why? He's looking for a giant payday. So this case has been going on more than a year. There's depositions, there have been multiple hearings. Why so much litigation? Because the tenant's attorney is looking for a giant payday. So you don't want to be the loser in an eviction as the landlord, because that judgment is a lien on your house. You're going to have to pay it. Changing the locks is another way to do an unlawful eviction, lock out the tenant. And lastly, to just throw the tenant's stuff out. That does happen a lot. I get calls from tenants all the time that they came home from work and their stuff is in the yard. So that's 3 months rent. Obviously, if you're the tenant and any of these things happen, the thing you need to do immediately is call the cops and document it. And then if you're lucky, the police will tell the landlord to let you back into the unit. But you still have your violation, and each violation is its own cause of action. So that's 3 months per incident. So you don't want to do any of these things. Just bear in mind, in Florida, if you have a problem with your tenant, your remedy is in the courthouse, not on the street. So don't do anything to the tenant at the property. File a lawsuit if there's a problem. Another thing that the landlord's not supposed to do is retaliation. So what's retaliation? Like discrimination, racial or religious discrimination. In Broward, there's all kinds of categories: sexual preference, age, even source of income. So you can't discriminate on someone who's on Section 8 as a source of income. So what would be a discriminatory act? Which would be to raise the rent, to not renew the tenancy, or to threaten the tenant for a discriminatory reason. So like with a lot of things, you can do things for no reason, but not for a discriminatory reason. So you don't have to renew everybody's lease, but if you don't renew the lease because of discrimination, now you have given the tenant a defense. The other thing is if the tenant did a protected activity, which usually is to ask for you to repair something. And then if you didn't, then they call code enforcement on you and you get a ticket. So then if you kick them out or raise the rent or don't renew because of that, then they have a defense. So where can you not, as a tenant, allege discrimination or protected activity? And that is where the eviction is based on cause. So the stuff that the landlord can't do for discrimination is stuff that has no cause, like raising the rent or refusing to renew. But if you have cause, then you can't sustain a defense of discrimination. So we already went through what is the cause: not paying the rent, violating the terms of the lease, or breaking the law. So if any of those are the case, there's not going to be any discrimination defense. So in landlord tenant law, which is unusual in America, attorney's fees are awarded to the winner. That's not the case in almost every field of law. So the only way in a lawsuit you get attorney's fees is it's in the statute, which it is in the landlord tenant statute, or it's in the contract you signed. So you'll see that most leases also have an attorney's fees provision for the prevailing party. So to remind you, the award of attorney's fees is there, but it's discretionary. So you may or may not get them, with the one exception of security deposit cases where attorney's fees are mandatory. That's why you got to be careful with the claim on security. So what is the attorney's fee going to be? The measure of it is a fair price for the lawyer and a reasonable amount of time spent on the job. So I just read a case this week where a lawyer was able to charge as much as $500 an hour because he was very senior and very expert. So that's a lot. But what's not allowed is that the same guy with $500 an hour also has a reputation for being super diligent. So he spends 3 times as much time doing everything as anyone else does. So the judge said, well, that may be your prerogative, but when you're asking someone else to foot the bill, I'm going to just give them regular amount of time. So writing up an eviction complaint, that would be an hour. If you spend 8 hours doing it, that's fine, but I'm not making the other side pay for 8 hours of work when a reasonable person could do it in 1. So what the attorney's fee is not proportionate to is the amount in controversy. So there was a lawsuit where the parties were fighting over $1,000 and the attorney's fees came to $60,000. So as long as the rate was fair and the amount of time was fair, they say that if you want to go to the mat, then you take the consequences. So you want to spend $60,000 fighting over 1,000 and you lose, you're going to pay the 60,000 as long as that is reasonable for what was done. So there, like I said, with that, the landlord that spent $4,000 not to pay $2,000, the amount of the fee is only proportionate about how much work was needed, not about how much you were fighting over. So there is a technical thing about fees. You have to ask for them up front, which means as the plaintiff in the complaint and as the defendant in your answer to say, I deny these charges and I ask for my fees. Secondly, after the court has ruled on the case, you must move for attorney's fees within 30 days. Okay, now we're ready for Q&A. Wendy, any questions?
Yes, there's a bunch of questions here. Let me read them to you. Okay, you might have answered some of these along the way, but maybe just repeat it quickly. If evicting, oh, what just happened to my chat? Hold on a second. Oh, when you turned off the screen, my chat. Okay. If evicting from a condo, where do you put tenants' contents since you can't leave them in the hallway?
That's not described. The statute says that you are to move the tenant's property to the property line. So that's what the statute says. Once you're entitled to do that, it's no longer your liability what happens to it. The one exception to that is that if the tenant finds your stuff in your house, you've stolen it. So just because you get to throw it away doesn't mean you get to steal it. And that has happened where the manager at the condo had all the tenant stuff in his garage and he got in trouble. So yes, there's rules. You can't just throw a pile of garbage around in a condo, but that's not addressed in the landlord tenant statute, just that it has to be moved to the curb. Don't steal it yourself. It will be stolen. It will be stolen so quickly, it's almost unbelievable. But it's gone fast.
Okay, next question. I don't know exactly what seller post occupancy. Not sure what he means by that.
Okay, sure. So in a closing, a lot of times the seller is asking for post-closing occupancy.
Oh, okay.
So as a lawyer, I don't like that because even though if you're doing your job, you're going to write up a lease and state that that seller is not an owner, he is a tenant, and he's going to be under the Landlord Tenant Act. The problem is that as soon as you try to kick him out because you didn't leave, he starts waving around the flag, hey, you know, I'm on title. It doesn't take that much for the eviction judge to say, well, unfortunately, I, as a county court judge, don't have authority to rule on that. So it's a very low burden to get your case transferred into circuit court where it's now an ejectment. So for that reason, I don't like post-closing occupancies at all. So if you have to do it, try to withhold as much of the sales proceeds as possible, preferably all of them. Definitely have a link.
That doesn't happen. I see a lot of post occupancies and they're not holding all the proceeds.
Right, so if you can postpone it, do, but make sure the lease is written and that it has an end date and it has a high rent so that if they're holdovers, then you're entitled to double rent. So just make sure you protect yourself, but it could get ugly because if that seller doesn't move out, they're not leaving until a judge tells them to leave. And if you're doing an ejectment in circuit court, you might be in court for 6 or 9 months. It takes, I just finished an ejectment. It took 3 months just to get a hearing date. And a lot of these cases have multiple hearings. So just be careful with post-closing occupancy.
We have a bunch of questions. It says, good afternoon. Okay, I posted your website information. Let's see. Unlawful detainer, landlord has to file themselves. What forms are needed?
All right, an unlawful detainer is not a landlord tenant action that's kicking out a guest, which is frequently a friend or a relative. And there really aren't any required forms. What I'd like to do is to have a written demand from the person in lawful possession to the person you're trying to get rid of saying, get out of my unit. So I do have a form on my website, browardlandlord.com, that you can give them, but unlike landlord tenant, where there's all those forms you have to use, unlawful detainer doesn't have mandatory forms. So what you're going to say is, I'm the one who has rightful possession of this unit, and I'm telling you to leave. So when you file the case, you're going to show that to the judge to say, see, judge, I told them to leave and they won't.
Can you put your, what was that website so I can post that here?
browardlandlord.com. And I saw someone asked, is it pointless to have a lease? No, because there are some things that aren't in a lease or in the statute, which is how much is the security deposit, how much are the late fees, the jury waiver, and the abandoned property agreement. So you do want to have those things.
Okay, when tenant pays less than security, landlord has to hold both in escrow or only security.
The statute only refers to the security. But again, there is no penalty for not putting in an escrow. There was only one case I ever saw, which is for a particularly horrible landlord that was losing the property to foreclosure. And he had collected last in security from the tenant. He was collecting rent even after the judgment of foreclosure was entered. And then he stripped the property with the tenant in place, meaning he took out all the appliances. So in that case, the judge was so mad at the landlord for collecting rent on a place in foreclosure, for not returning the security, and for taking the appliances during the tenancy, that he did bust the landlord for not keeping it in escrow. But that was more on the basis that the landlord's action went to the level of being civil theft. But in general, you're not going to get in trouble for not escrowing it.
And we have a lot of questions here. So what are the deadlines for commercial properties for month-to-month notice?
They're similar, without having to look at the statute. I do have all the forms on my website and instructions on all the forms. So just go to browardlandlord.com in the form section and you'll see all those notices. That some of the periods are longer for commercial than residential, but it'll say on the forms that are on the site.
Awesome. So we can get all the forms from your website. That's great.
right?
3-day notice is only for rent, and when and where do you ask for late fees that's listed in the lease agreement?
Well, to do that, you either wait till the end and put it on the security deposit, or you can do an accounting trick, which is, let's say that they paid April late. So then May comes around, they pay May, but you take $100 from the May rent and you apply it to the late fee. Now they're delinquent for May.
Okay,
So you're not asking for a late fee per se, it's just that you applied some of their payment towards late fees.
if the addendum says that the late fee and legal fees is part of the rent, could you put that in the 3-day notice?
No. No, nothing but rent in the 3-day notice.
Are you allowed to ask for a copy of the applicant's social security card?
Yes, you should.
If tenant pays rent after 3-day notice, if they deposit it into landlord's account, how quickly must the landlord return rent so court doesn't rule that the landlord accepted the rent?
So wait a second, are you saying if the tenant paid rent after the case was filed?
It says if tenant pays rent after 3-day notice, if they deposit to the landlord's account, how quickly must the landlord return the rent so court doesn't rule that the landlord accepted the rent?
Okay, when you hit the midnight of the 3rd day of the notice, the rent is irrevocable, the tenancy is irrevocably terminated. There is no right of reinstatement. But, so the landlord is not required to accept a late pay or a short pay. But now that we have all these direct deposit things, it could be the tenant goes ahead and gives you either a late pay or a short pay. So you got to kick that back immediately. Literally think of it as a ticking bomb. Because yes, if you sit on it, you've deemed to have accepted it. Therefore, if you already went and filed the lawsuit and you didn't give that money back, you have waived your lawsuit and the lawsuit will be subject to dismissal. So,
Because it's very tricky with the Zelle or the Cash App that they can
yeah,
just,
because you can't stop
send it
it
to
from
you.
coming in.
right,
So you got to keep an eye open for that and either kick it back to the tenant, or if the case has already been filed, you can go ahead and deposit that money in the court registry. The slight downside to that is that they charge a fee of like 5%. But rather than give the money back, you can dump it in the court registry and collect it later. But you can't just keep it in your own bank account.
okay, and then do you have all these items on your lease, and can you put more than one security deposit in one account?
Well, again, no penalties from mismanagement of security deposits, so that doesn't matter. I do have my version of the lease on my website that you're free to use.
That's awesome, I
And-
love that.
And again, when it comes down to it, it's going to be up to your personal preferences. For me, for repairs, I like to leave it as the landlord's not doing any repairs. But some landlords feel more comfortable saying any repair below 250 is on the tenant. Just so that if that's a clogged toilet, then the tenant understands that they're responsible for the plumbing bill. So for me, I just say I'm not doing anything, but if you feel that it's more incentive to put a threshold, like the first 250 is on the tenant, then do it whatever way you're comfortable with.
Okay, can you send an email to the tenant in reference of the security deposit?
No. There's no way to claim the deposit except the certified letter. Even hand delivery is not sufficient. Certainly not email. I get a lot of that. The landlord sends an email, they blew it.
What about tenant early termination? How does a landlord appropriately close the security deposit?
Well, you've got a choice on early termination, which is standard result is that the tenant remains liable for the rent as it accrues for the duration of the lease until you get a substitute tenant. So there's two things. One, you can't ask for rent in residential before it's due. And secondly, you can't double dip, meaning if somebody bails out in April and you have a new tenant for May, you're made whole. So that old tenant doesn't owe you anything.
Okay, what if tenants' original paint colors, i.e. multiple different outrageous colors?
I think in that case, since this is not standard, that you could charge for the paint.
Okay, good. And I'll be able to share the slides. I'll be able to share the recording, but not the slides, correct?
You can share the whole thing
Oh, so you'll send me the slides too?
if you'd like.
Okay.
Assuming
People
that
are
when you
asking,
recorded it, the slides were recorded as well, but
I know, but some people are asking if you can send the slides separately.
sure, I can email you, Wendy, the PowerPoint.
Okay, awesome. Thank you. If only one unit, can landlord keep deposit in checking account?
Again, the rules say no, but there's no penalty.
Okay, so. I saw the Help Me Howard show, and in a case people moved into a house they never paid, leave, nor did they have lease. Attorney said he can call police to remove them without going to court with eviction. I guess he said unlawful detainer, but he didn't have to go to court for that. The police removed them. Also, in another case, how can we get a homeless person out who invited themselves into an elderly home without permission? Elderly rents, don't they own? Don't we know what that question is exactly?
Okay, so with regard to a trespasser, officially, the police should remove a trespasser. The one thing the police are not supposed to remove is a tenant. A tenant can only be removed by court order. However, the police are very skittish about this. So you will find them refusing to remove people and telling you to evict them. So they don't know what unlawful detainer is, so they'll always tell you eviction. But officially, as long as someone didn't pay you any money and they've entered your unit, unlawful detainer, well, actually, the full title of the statute is unlawful entry and detainer. So unlawful entry is meaning you entered the property without the owner's permission. So that's like the homeless guy. And then detainer means you stayed after the permission was revoked. Like if you were at a bar and the bar closes, you're supposed to leave. If you don't, they can kick you out. So since you don't have a lawful right to stay there against the owner's will, then they should kick you out. But again, the police sometimes get nervous about that and tell you to file a lawsuit. So with the situation of the guest and the unlawful detainer, technically you should never have to do an unlawful detainer because guests don't have any rights. Tenants have rights because you conveyed them the right of possession, like if you conveyed a deed to somebody. But guests don't have rights. If somebody comes over for coffee and you tell them, all right, party's over, time to go, and they don't go, it would be ridiculous to file a lawsuit, but the police get jumpy about that if you've been there for a while. Now, the boundary line is 30 days. Less than 30 days, you're a transient, which means you can be removed. And in fact, there's even a statute and a form, which I have on my site, which is affidavit of removal of transient occupant. So it is possible, but I find that the police enforcement of that is spotty. So yes, with that person that moved in and didn't pay rent, I guess technically because they didn't pay, that made them a trespasser or something, not a tenant. That's a little bit of a close call because it sounds like for the first person, the idea was that they would be a tenant. Certainly for someone who just wanders into the property, they're a trespasser. And the police should remove them, but let's say they've been there for a month. Then now, after it's 30 days, they're not a transient anymore.
So, Alexander, we actually have a lot of questions. I don't know if we can run through them or if I can send you, you can see the chat and we can answer them all in an email. So I know we're kind of running late here. So what do you think? Can we answer them quickly, or do you want me? you
Yeah,
want
let me
us-
try to run them through.
Okay, so we have a lot, so let's kind of try to go quick. Let's see. Just going through them. What about, hold on. Owners. Sorry, I was just. If a tenant realizes that there is mold from the AC outlets and he looks for a specialist and verifies it, the tenant sends the results to the landlord and he tells them that this is the tenant's expense. Everyone in the house has several coughs, sometimes with bad flu, and apparently it's because of the situation, and he keeps saying that he doesn't have to fix it. That is exclusively the tenant's expense. Is this true, and what can the tenant do? So we need to answer quickly if we're gonna get to all these, okay?
Sure. So I would say that mold is a very frequent cause for fighting between landlords and tenants. So for the tenant to properly address the issue, they need to issue the 7-day notice, and then that puts the burden on the landlord to act reasonably. I will just say anecdotally that because Florida is a very humid place, that there can be mold that grows on surfaces, just like on your old bread in the refrigerator. That's not the kind of mold that gets anybody sick. That's because the humidity is too high. You need to dehumidify, which is normally accomplished by your air conditioning unit. The mold that's dangerous is the mold from a leak, whether it's a roof leak or a pipe leak. So when you have a constant source of water that's dripping inside the walls and your drywall is like a sponge. So once your drywall is soaked with water for a long period of time, mold will start growing in it. And at that point, that mold is a health issue. And the only way to remedy it is to rip out all the drywall. So we're talking about a big deal, like 5 figures worth of repairs. It's going to be disruptive of everyone's life. But if you just see some mold sitting on a surface, you need to check your humidity and, run the AC and close the windows. But the bottom line is it's based on the 7-day notice. So until the landlord gets one, he doesn't have a duty. And then when he does get one, his duty is to be reasonable. If
One
you're a
other,
tenant, just as the last thing on that, it's going to be nearly impossible for a tenant to sue the landlord successfully for personal injury because they're never going to be able to prove causality.
okay, if the landlord evicted the person and took him to small claims court and won, the judge said tenant had to pay the month's rent with interest. What can we do if they don't pay?
Well, if a judge orders a tenant to pay the rent and you violate that order, the judge is going to grant the eviction as soon as he sees that money hasn't been paid. Normally, he's going to order you to pay it to the registry so the judge will know. I've never seen the judge ask for interest to be added, but if a judge orders you to do something and you don't do it, then you're going to get evicted. Normally without any further hearings, just file an affidavit of noncompliance.
Okay, when tenant pays less in security, landlord has to hold both in escrow or only security.
It doesn't matter.
Okay, is it pointless to write a lease?
No, because the lease, if you have no lease, you don't have anything about late fee, security deposits, jury waiver, disposing of.
Need to write a lease. Okay, can landlord add addendum with other specifications as part of the lease contract?
Yes. So it's not unusual to see an add-on like rules and regulations that get a lot more specific about behavior.
Okay, is it advisable to put rental properties in an LLC for protection?
Yeah, and I'm sure you run into this all the time too, Wendy, is the concept of bleeding liens where you own a lot of properties in the same name and then you get a code violation. And now that violation is attached to every property you own. So I recommend not only is it not in your personal name, but you don't own more than one property in any one name.
Right. Okay, what limits for late fee can we add per day?
No limits.
During COVID evictions, an eviction of possession and non-payment of rent was entered in court but never finished. The tenants left to another state. Is it possible to reinstate?
reinstate the eviction?
Yes.
No, because once possession has been restored, there's no cause of action.
Okay, somebody said I still need an answer on post occupancy.
Don't like it, but as Wendy says, sometimes it's gonna happen.
You don't have a choice. Okay, if repairs $400 more than the repair limit, $200. Can landlord ask tenant to pay $200 and landlord pays the rest?
Yeah, that's up to you. I mean, for me, I just say I'm not fixing anything. But if you want to put the first 200, that's another way to approach the problem.
Okay, well, I
I mean,
think
the
we
main thing
got
that comes up is clogged toilets. Obviously, as the landlord, you're not the one who clogged the toilet, so why should you have to fix it? So I like all of that to go on the tenant. Definitely warn them about those flushable wipes. They don't degrade. They will get caught in your iron pipe and form a clog. It's a huge issue.
So awesome. Thank you so much. I will send a copy of the slides when you send them to me, and I'll send a copy of the recording. I'll share that with you either later today or tomorrow, everybody. And I think it was an awesome meeting. We're going to do another seminar probably in June or July. We're going to talk about specifically rentals as pertaining to real estate and realtors. I know we went into a lot of depth today, so we're going to come from a little bit of a different angle in that class. And I know Alexander is working on that, so I'll be sharing that with you probably June or July. Once again, Wendy Rosenberg, Vice President of South Florida Title Associates, the Nob Hill Sawgrass branch. I hope that you guys all enjoyed the seminar today. And when you need a title company, you're going to think of me, Wendy Rosenberg, South Florida Title Associates, Nob Hill, Sky Square Sawgrass branch. That's all me. Really love working with you and educating you. And I know that you guys are loving my classes. And I just hope that in return, you're going to use me for your next deal or the one after. I'd be super, super grateful. And I do see a lot of you out here who have been working with me. And I want you to know I really appreciate it. And those of you who have given us a shot seem to really like us because we are doing an awesome job and our fees are super reasonable. And once you start, you're just going to want to continue because we do such an amazing job and we have such great fees. And you always have my contact information, and I reach out to your clients directly. When you tell them that I'm the vice president, they love that. When I do their closings, they're so happy. And my staff is really amazing. I can totally tell you that. In addition to great pricing, amazing staff, amazing follow-up, and communication with me, you guys, it's a win-win. So keep me in mind on your next deal. I really would appreciate it. And thank you so much to Alexander. I have a few more classes coming up. I'm not sure exactly. I had to make some changes in the schedule, but I have, weekly or every other week from now till, I don't know, indefinitely. I do have an in-person lunch and learn in May. It's going to be for 2 CE credits. I will go over, I'm trying to update my calendar. I will be away for 2 weeks in May, so I won't have classes then. But my office will still be up and running, handling all your deals. And even though I'm away, I'll know what's going on in the background. So I'm always hands-on, very hands-on to all of my files. And I'm always here for you. So once again, keep me in mind, Wendy Rosenberg, South Florida Title Associates, the Nob Hill branch. Have a great day. Stay safe. Try to stay out of the rain. And thanks again to Alexander. Awesome presentation. And as soon as you send me the slides, Alexander, I'll put it together to send them out to everybody. Okay. Thanks so much, everybody. And bye-bye.
Great one. Thank you so much, guys. Thank you.
Thank you.
Bye-bye.